Good morning to one and all. Professor Dr. T.R. Subramanya, Dean School of Legal Studies, Professor Dr. V.J. Praneshwaran Sir, Director School of Legal Studies, faculty members, researchers, and scholars who have joined us today this morning. I welcome you all. In continuation with the series of lectures of the FTP program, we have amongst us today Professor Dr. Purvi Pokhariyal. We welcome you, ma'am. Professor Dr. Purvi Pokhariyal is the Director of Academics, Research and Consultancy at the National Forensic Science University, Gandhinagar, Gujarat. She is also the founding Dean of the School of Law, Forensic Justice and Policy Studies and the Dean of School of Forensic Psychology at the National Forensic Science University, Gandhinagar. With more than 25 years of academic and industry experience in the field of law and justice administration, Professor Pokhariyal specializes in the area of criminal justice studies and justice education. She holds a master's degree in law with specialization in criminal law and her doctoral degree in constitutional law from Maharaja Sayajirao University of Baroda, Vadodara. She's been a consultant and a resource person on various aspects of legal studies for government as well as non-government organizations. Professor Pokhariyal has been conferred with the distinction of being the first ever female chairperson of the Indian Society of Criminology and was also conferred with Senior Social Scientist Award by the Indian Society of Criminology for a significant contribution to the field. Professor Pokhariyal was also selected for the Best Law Professor Award by the Business School Affairs, Devang Mehta National Education Awards. She is also a visiting faculty at HOF University, Germany, and a resource person at various training programs, workshops, and national and international conferences. With more than 50 papers to her credit, she has presented extensively in various national and international conferences and also has been the editor of many academic law journals. She has conducted various FDPs for law teachers on innovative pedagogy for law teaching, outcome-based education for law schools, clinical legal education, justice education, etc. Professor Pokhariyal has also conducted several training programs for law enforcement agencies, public prosecutors, and police agency, and is also associated with State Judicial Academy and Police Academy as a resource person. We welcome you, ma'am, and we are very happy to have you amongst us today.
Thank you so much. I'm glad to be the part of this faculty development program, and I'm thankful to Professor T.R. Subramaniam for having me invited over here for this program. Well, today the topic on which I'm going to discuss is about emerging crimes, criminal justice delivery system, and its integration with the forensic science. Well, friends, as you all are aware that the modern day state is not only looking after the law and order situation, but its major task is all about the welfare of people, right? Now, when we talk about the welfare of people, it's all about how do we ensure the greater good for the greater amount of people. In all these holistic development, what we call is a human development index, right? How do we ensure the overall happiness? Now, for this, what do we need? We need laws, we need policies, we need system in place, and we need the procedural aspect, that how do we operationalize all this system. So this is what is the need of the hour. Now, when we talk about the systems, laws, procedure, and entire operation mechanism, what do we really want? We want a competent, trained human resources in every sector. It could be any sector. It could be the social sector. It would be the justice delivery sector. It could be a police force. In all these sectors of human governance, we need competent people. We need right kind of people who have a scientific temperament. And this is very, very important, specifically for the criminal justice delivery system, because when we talk about the criminalization and the entire consequences of the criminal justice delivery system is someone is getting punished. As we all know, someone is getting punished, someone is being sent behind the bars, someone is there whose fundamental right is somewhere is going to be compromised, fundamental right of life and personal liberty. So criminal justice system has a consequences wherein the edifice of the human existence is getting challenged. And that's the reason that when we are operating the criminal justice delivery system, we have to be absolutely sure and we have to be absolutely objective in our approach, because somewhere you are trying to put forth the basic human rights of an individual. You are going to affect or someone's basic human right is going to get jeopardized because of the criminal justice delivery system. And the basic human right, as I said, is fundamental right to life and personal liberty. And that's the reason that I'm always being reminded of a fundamental duty enshrined under the Constitution of India. And this is one duty which is very, very close to my heart. And of course, it should be our approach as academicians as well. And it says one of the fundamental duties says it is a duty of every citizen to develop a scientific temper, right? If you remember, it is a fundamental duty of every citizen to develop a scientific temper and spirit of inquiry and reform for the humanity. So in this context, when we talk about the criminal justice delivery system, and since we have all sophisticated crimes which are getting emerging every day, the new methods, new pattern, new tools, new techniques, new software, all kind of a different cyber frauds, cryptocurrency, blockchain, deepfake, we get to the dark web, all these kind of a new sophisticated tools, techniques, new what do you call modus operandi that comes that we all are reading and finding. At that point in time, it's very, very important that we also counter this criminal activity with the scientific temperament, with with some kind of an objective scientific tools, techniques, and mechanism. And there where the use of forensic science comes into handy. Forensic science was not very prevalent in the entire delivery of the criminal justice system till last 20 years. I mean, up till before 20 years, it was not much very prominent, because the reliability was an issue, the competency was an issue, the and that's the reason that it was very difficult for people who were operating the CJS for them to appreciate the importance of a forensic sciences. But for the last couple of decades, there has been a greater amount of reliance, greater amount of uh, development in the area of forensic science. And that's the reason that today we have reached to the kind of a state of affairs, and we are still marching on these roads, that instead of any kind of a third degree treatment, instead of any, even during the investigation, during the trial, we have to have greater reliance on the forensic evidence, because at some point in time, there is some understanding that is getting developed, is that forensic science is a scientific evidence. Forensic science provides a reliable evidence. Forensic science somewhere creates an objective outlook to the entire case. And that's precisely the reason that we need to have more integration of the forensic science with the criminal justice delivery system. So with this preamble, I just would like to share a small presentation. This is the place from where I belong. I mean, National Forensic Sciences University, as some of you may be aware, it is the exclusive forensic science university, and this is one of its kind in the entire world as of now. And it has been set up in the year 2020 during the COVID pandemic. And in 2023, we have 11 campuses of this university in different parts of the country, and one campus offshore as well. It is in Uganda. So, as of now, because this is what precisely I wanted to share, that over a period of time, there has been an understanding that is getting developed that forensic evidence is something which we cannot ignore for a quite a long time. And we need to generate competent and capable human resources who can deal with this kind of sciences. And that's the reason that the government of the day has felt that there is a dearth of expert forensic scientists in this country, and we need to have, because India is one of the biggest democracy of the world, and for the biggest democracy of the world, wherein the conviction rate is as low as 30 to 40%, is a greater challenge for maintaining the law and order in the country. And that's precisely the reason that the government thought that forensic evidence only may come to the rescue of the CJS in terms of strengthening the entire justice delivery system and ensuring the speedy and fair justice. And in keeping these ideology in mind, the government really wants to promote the forensic science education in the entire country. And we have now 10 campuses, including Gujarat, Delhi, Goa, Tripura, Bhopal, Pune, Guwahati, Manipur, Dharwad, and one in Uganda. So this is brief about the university from where I come from. Now, as I said, even the Supreme Court has also realized the understanding of this forensic science, forensic evidence. In Dharamdev Yadav versus State of Uttar Pradesh, the court held that the constant interaction of judges with scientists and engineers would promote and widen their knowledge and deal with such scientific evidence, and so that they can effectively deal with the criminal cases based on scientific evidence. Because at times what happens that unless and until there is a deeper understanding about how this evidence is being extracted, how this evidence is being generated, how the report has been written based upon this forensic examination, scientific examination, and how that particular aspect is the fact is being proved or disproved based upon the scientific examination. If this whole process is not being properly understood by the public prosecutor or by judicial officers, then no matter what maybe the science is, but the forensic science and forensic evidence may not come to the rescue of the criminal justice delivery system. And that's precisely the reason that it is being reiterated in number of cases by different high courts and the Supreme Court as well, that there has to be there has to be a greater amount of interactions of judges and lawyers with the forensic scientists, engineers, technocrats, in order to understand that how this evidence is getting generated. Because most of the times what happens that all of us, we live in our own silos, right? The lawyers community, the judges community, the scientists, the engineers, the technocrats, they don't interact much about their field and expertise, and they don't share that common vision and understanding. And that is the reason that interdisciplinary or interprofessional insights, which is so important to run the entire governance, is at times getting missed. And that's precisely the reason that the university like us is not only imparting education, but we also have lot of continued training program for the judicial officers, for the public prosecutors, for the police officers, how to investigate based upon the scientific temperament, and how to collect the right piece of evidence, how to examine, how one should not miss out at the time of investigation and interrogation. What are the different soft techniques of interrogation based upon the neurotech devices? So all this thing, that is what the university is engaged with. So when we talk about the forensic science and forensic per se as a science. What do we really need? As I said earlier, we need highly diversified, because we know that as of now, the crime nature is highly diversified, and culpability and its degree is really, really reaching to a different kinds of heights. And that's the reason that what do we need? We need a well-trained, well-equipped law enforcement officers, law enforcement agencies who investigate, because everything is based on the charge sheet. Everything is based upon, because trial comes at the later stage. But what is more important that the charge sheet, what kind of a piece of evidence is that you're collecting? How do you examine? How much time you are taking in collecting this piece of evidences from the scene, from the crime scene? All these things is very, very vital. If your charge sheet and the investigation is weak, then we cannot do much in the trial part. And that's the reason that the first and the foremost thing is to train the law enforcement agencies and on how to investigate at the scene, crime scene. And that's precisely the reason that now in most of the states, including Karnataka, you may be aware that they in Karnataka there is a special cadre is known as a SOCO officer, scene of crime officers, and the scene of crime officers basically is they are the part of the law enforcement agencies, but they are specifically being trained and equipped with the understanding of the forensic examination and collection of an evidences, preservation of the samples, and how much the sample how to collect the sample, in what vessel the sample is to be collected, how do we preserve it so that that particular sample does not get contaminated, how much time you can preserve the sample before you send the sample to the forensic sciences laboratory, in how much time this sample is to be analyzed in the forensic science laboratory in order to ensure that it does not loses its evidentiary value. So some samples are of the perishable nature, so you have to maintain the time frame. So these kind of an understanding that is getting developed by these crime scene officers, we call as the SOCO officers. And so right from the investigation, the forensic science comes into picture. And then subsequently, when the same sample goes to the forensic sciences laboratory, there also in the FSLs also, you need to have a very skilled workforces, all the scientific assistant and the scientific officers, the senior scientific officers, they all need to be well equipped with all the latest technology. Sometimes what happens in forensic science laboratories, some instrument that we might have purchased in 90s on in 80s, and the same instrument is not getting properly calibrated, and then we are doing all our experiments in this on the same instrument without ensuring its efficacy. So because nowadays we have all kind of we have such an advancement in the technology also, that we have more and more sophisticated technology comes into picture. Like I just give the example that earlier when we have to extract a DNA, then it used to take so much of long period because that required the gestation period. But now we have a very ultra modern, sophisticated equipments wherein we have a technology in place wherein from the taste touch DNA or a trace DNA, you can extract the DNA within few hours. Within 24 hours you get the DNA result. So whether these officers who are working in the FSLs are also being properly skilled and trained with all these new techniques or not, that's also a concern. And I'm very glad to share over here that the university is also constantly engaging with the forensic science officers. As of now, also there are 100 officers from Karnataka is there at a university campus getting trained for 3 months on all these aspects. So any new officers who are being recruited in the forensic science laboratory has to have undergo some kind of a 1 month to 3 month training at the National Forensic Sciences University. That is the arrangement the government has done. So I mean, not only Karnataka, but from other states also, from Jammu, from Uttarakhand, from UP. So there is a constant training that is going on with these FSL officers as well. And then comes the judiciary, because once that forensic science report is being received and is being included as a part of the charge sheet being submitted before the court of law, then the real trial begins. At that point in time, we need to have a well-equipped judiciary who has a basic understanding of the forensic sciences and how the report, how uh, the sample was being collected, how the particular evidence has been extracted from the sample, whether the all standard operating procedure is being followed or not, what could be the loopholes, how the DNA report which is being presented in the court of law can be read, what how do we write the report, how do we read the report, is also very important to understand. And that's the reason that there has to be a constant interaction of judiciary with the forensic science fraternity, and that also precisely which these universities engage with. You'll be happy to share that in on these weekend only, on 29-30, we have around 70 judicial officers all over country. They are getting the training on the DNA evidence. We have some very highly sophisticated DNA extraction techniques, which we call is a touch DNA. Because as we all know, whatever places, suppose I'm putting my hands on this laptop, I'm putting my hands on table, from everywhere, even from the slightest of the touch, now we have the technique that you can, from the touch DNA, from that place, I'm leaving some residuary of my skin over there, and from the skin, even the small particle of my hair, from small nail, or from some traces of my body part on any object, from there also you can extract the DNA. So what is this touch DNA technique, and how does it work? How does it change the entire gamut of the evidentiary value in the criminal justice system, is something which we are going to discuss with all the judges on this weekend. Because what is more important is to understand that now all over the world, everyone has accepted that DNA technology, the DNA has transformed not only in the medicine, I mean, not only in the medical field, but DNA has also getting transformed the justice delivery field. Because, and that's the reason that DNA is being considered as the gold standard of evidence. You can't refute, provided the all SOPs and all techniques is being properly followed, and the standard operating procedure when you're operating that markers and the equipments is also being properly observed, it becomes the gold standard evidence. So this is the nexus. Of course, then comes the training for the forensic advocacy, because the most important thing in any trial is also the public prosecution, how effectively public prosecutors is presenting its case, and how he is being able to read the forensic report, and how he is being able to rely upon those evidence in the trial, and how he is putting forth his arguments based upon this thing in the court of law. And that's the reason that training of the public prosecutors is also equally important, which we are engaged with. Not only this, but we also have a defense counsel, which we need to have a better understanding of the forensic science, because forensic science is not only for the conviction of the cases. Forensic science is also for exonerating of the innocent people, because just because of some other evidences, some people, some accused are getting a punishment, is getting convicted. At that point in time, for the convicted people also, the forensic evidence and the forensic science comes to their rescue, because with the help of the forensic evidence, they can prove their innocence. And most of you may be aware there is a great project that is going on in the United States Supreme Court. It is known as the Innocence Project. To all those people who are being convicted and they are serving their sentence in the prison, and if they feel that they are really innocent, they can request for the reopening of their requesting for the reopening their case or retrial. and then again the forensic evidence can be examined, and based upon that, what you call, they can also be exonerated. It is known as an innocence project. Uh, so this is even for the defense counsel per se, it is very important. This is how the forensics and inclusion of forensics in legal academia. There has been one of the uh, DGP conference, and there has been uh, the whole discussion that is going on, that all the law schools in the country should also teach forensic science to the law students, because forensic science is not only for the criminal justice system. Even when we talk about the civil cases, especially in terms of the property disputes, in terms of the insurance claim, there are so many areas wherein the fingerprint sciences and the question document sciences, because the document analysis, all these things that comes into foray. And that's the reason that forensic science understanding is also to be provided to all the law students. And this in this context only, last year we had a roundtable discussion with all the national law schools vice chancellors and the other law schools. We invited everyone, and we prepared and we devised a standard syllabus for the forensic science course that can be discussed and deliberated in all the law schools. And the National Forensic Sciences University has also given an open invitation to all the law schools, that if any law school does not have forensic science laboratory facilities and want their students to have some kind of a practical training, the university is extending all its support and invitation to all the law schools to get because to get the students trained, or to have some kind of a knowledge that can be acquired by the students with the help of these different laboratories that the university has set up. So this is how the whole nexus of forensic science and legal profession. Now, what are the challenges? Yes, there are some challenges with reference to the forensic science, and the first is uh, what happens is why we need forensic science. We need forensic science because it brings a lot of objectivity, it brings a lot of scientific temperament, and it is that science which you cannot refute. All other evidences, like we have seen, even the eyewitness testimony can also be questioned or can also be wrong. But then when it comes to the science, there's some scientific result which we cannot deny, and that's the reason that you can have a greater amount of reliance on the forensic evidence. uh, and when you are relying on the science, it is always a less time consuming. You are just testing a particular evidence on different equipments, through different technology, and the result is there. You need not to extract the truth from different sources. From the collection of the sample, if it is being properly collected, the sample at the crime scene may also give a lot of insights into the evidences. And that's the reason that it is less time consuming, it is more efficient, it requires a less workforce, and it is very convenient in the complex cases. And that's the reason that the forensic science and the forensic evidences is getting more momentum in the justice delivery system. Now, this is something which all of us know. Hello, am I audible?
Yes, ma'am.
Yes, ma'am, you are audible.
Yeah, audible.
Complete silence, so I thought whether okay. No, okay, thank you. This is something which you all know. When we talk about the forensic evidence, it is always being considered as an expert opinion under Section 45 of the Indian Evidence Act, or if those agencies who are being notified under Section 293 of CRPC, wherein basically all the all the agencies which are mentioned in 293 is all the Fingerprint Bureau and Chemical Sciences Laboratory, and whatever the report that is being generated by those agencies listed under Section 293, that report can directly be given in the court of law, and it is admissible in the forensic evidence. I'm here also very happy to share one thing, that National Forensic Sciences University, all the professors, associate professor, assistant professors, all the scientific officers of the university, they are now recognized under Section 293. Recently only the government has issued a notification specifically mentioning that all professor, associate professor, assistant professor, and all the scientific officers who are being appointed in the technical cadre, they all are now coming within the purview of Section 293, meaning thereby whatever the case that comes to the National Forensic Science University and is being investigated, is being investigated in terms of the forensic science examination, is being examined and analyzed by the university in different laboratories and centers. That report is directly now admissible before the court of law. So this is all whose officers and professors are getting this kind of a status, that that report is now directly admissible before the court of law under Section 293. So now, as we all know, 45 and 293, these two entry, the forensic evidence or scientific evidence comes into the justice delivery system. Now, we know that evidence could be a document. So documents is defined under Section 3 or Section 65B. When it comes to the electronic evidence, you need to give the 65B certificate. Oral testimony witness, that is under Section 60. Now, again, in the oral testimony, we have a layered voice analysis techniques, wherein through the LVA method, with that layered voice analysis is again a scientific instrument, or I would say the equipment through which you can test you can test the reliability of the statement made by the witness or the accused, or even the victim, so that through this it has a techniques that when you lie, when any person lie, the frequency of their voice frequency gets differ than the person who speaks normally. Because whenever we lie, we try to suppress something in our body, right? Lie doesn't happen so naturally to most of us. Whenever anyone is providing a false information, meaning thereby he's trying to suppress the truth, he's trying to suppress the real facts. At that point in time, to suppress that fact, to suppress the truth, you need to invest some more energy in different parts of your body, and that always reflects in the frequency of your voice. So through the layered voice analysis, we can even test the reliability of the statement made by different different stakeholders. Then, of course, when we talk about the circumstantial evidence, we gathered all kind of samples, and even the circumstantial evidence. Now we have a very sophisticated forensic and investigative techniques that comes into picture. We have a different instrument we call is a eye detect system, suspect detect system. We call it a polygraph. We call it a brain fingerprinting, wherein you are being you suppose I'm giving the example of the BIOS system, through which there is a neurological cap that is being worn by the concerned object, and then he doesn't have to say anything. He just have to listen with reference to the he just have to listen the narration of the sequence that of the crime that has happened. So someone would be talking about that at so and so time, some so and so person had gone to the bank of the river so and then has done this and has done this. So if anyway he is involved, because if anyway he is involved either as an accused or as a witness, then immediately he would give the neurological responses which would be captured in the laptop attached with the system. So even though he is not being said anything, he is not saying yes or no, he is not narrating anything, he is not giving a single sentence, but the way in which he listens, because it works in the very simple cognitive techniques, that if I ask all of you that close your eyes and don't think about the picture of a peacock. The moment I say don't think about the picture of peacock, immediately what will come into your mind is a picture of peacock, isn't it? So it works on these neural frontal memory, that if anything that any scene that happens before us, that memory is somewhere stored in our neural frontal lobe, and then that gets activated when someone is trying to recall these things, and the moment it gets activated, the neuron gets active, and then that is being reflected through these wire transmission. So these are different techniques that polygraph, brain profiling, suspect detect system. We have a expression, neuro micro expression, wherein you are being asked to sit before the computer, and you are just being asked a couple of questions, that how do you feel, how are you, what had happened at particular day. So whatever you say, your extremely micro expression of your face gets captured there in the computer, in the laptop. So if someone asks you that how are you, I mean, are you enjoying coming over here, and you just want to say, most of us, at so many occasions we just give an artificial smile, or we just give some lie answer. Yes, 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 I'm very happy, I'm all okay, God, thank you. No matter what, we may be in a lot of stress, or a lot of anxiety, a lot of sadness, or some very bad thoughts that might be going on in our mind. But if someone comes before us and said, hello, how are you? And you say, yes, yes, we are fine, thank you, right? Immediately, because that's what we are being wired. But then if you are not fine, that is being captured in the extremely micro expression tools which is there. So, now what I'm trying to tell you is that these are a very different kind of technology which is now available, and I'm very happy to share over here that the university at our place has a very sophisticated center of excellence of forensic and investigative psychology, wherein all these equipments and technology is available. If any time your time permits, I would request Professor Subramaniam to come. Now we have an MOU also. You can come and pay a visit to different kind of advancement that is happening in this forensic field, and can get a better insights for all the faculty members and the students as well. So the point I'm not taking much of your time on this, but the point I'm trying to make over here is that all this under the documentary evidences, oral evidences, or circumstantial evidences, and all these three evidences, in all categories, the category of the evidences, we have a scope of extracting the forensic evidence through different methods. The only issue that lies is, suppose we all remember the Selvi versus State of Karnataka case in 2010, when the Supreme Court says that if you really want to have a polygraph, because that's Article 23 Article 20 subclause 3 comes into picture, wherein you cannot violate the self-incrimination constitutional rights guaranteed under the Constitution of India. So you need to acquire a consent of the accused or any subject matter whom you really want to go for polygraph. So there are certain procedures which are being laid down under Selvi versus State of Karnataka. So it has some issues are self-incrimination, privacy, at times the accuracy, because if the person who is operating the system, he has to follow all kind of an SOPs which are being set forth to operate that machine. If it is not being followed, then of course it may lead to a different kind of a result. So accuracy is to be observed. And then comes the issue of admissibility, and all these three evidence. I'm not discussing all the cases. I may not have much time, but yes, as I said, there are different kind of forensic evidences. We have psychological evidences, toxicological evidences, cyber forensics, forensic anthropology, digital forensic, forensic odontology, forensic biology, and of course the forensic and investigative psychology. Then of course the DNA, ballistics, serology, fingerprints. All these are the physical sciences that is comes into picture. So this is all. Very important, and this is something which is even the Latin during the Roman era also. All this particular criminalistic techniques, fingerprints, DNA, ballistics, they were being introduced during the Roman era as well. As I said, as long as way back in 1247, the oldest book on forensic medicine in the world in Chinese civilization, and it was being considered, it was written as a guide for magistrates in conducting inquest. The book, which is a major source of early Chinese knowledge of pathology. So, right from 13th century, 3000 BC, we have an Egyptian civilization wherein, we were removing and preserving all internal organs through mummification. So that is also one of the techniques to preserve this the evidence. And of course, we have the Julius Caesar's case. I'm not discussing all these things, but when it comes to India, yes, the first fingerprint bureau of the world that was being established in 1897 in Kolkata, and so this is the history. Everything in the forensic science in India has started with this Kolkata state. Yeah, and yes, what are the how the forensic evidence comes into the criminal procedure? Yes, it helps to establish the identity of the victim, identity of the accused, detection, that is the detection of criminal, highlight the relation between accused and the victim along with the crime scene. It also establishes the identity of the people involved in the commission of the said crime, not only the criminal, but what are the other people who are also have abetted or somewhere involved as a perpetrator of crime. And of course, it also exonerates the innocents, as I discussed about the Innocence Project in the United States. It also corroborates the victim's testimony at times, because the corroboration also the forensic evidence comes into picture. And yes, it assists in proving the facts that are connected to the crime. So these are the different advantages of the forensic evidence in the criminal procedure. And as I said, these are different kinds of evidences. Biological evidence that all includes the blood, saliva, even stains, urine, perspiration. All this uh, comes as a biological evidence. Weapon evidence, so that all firearms, some is handgun, revolver, rifle, even the used fire projectiles is also being considered, gunshot residue, everything that can be analyzed and is being covered under the weapon evidence. Fingerprint evidence, which is a greater importance nowadays, and this is the only fingerprint evidence now. It is being recorded under the Nafis software. India has largest database of the fingerprint evidence as of now. uh, Drug evidence, impressions, so all these things that comes into trace evidence, as I said, even the fiber, hair, cigarette, the residue, tobacco residue, glass. From there, you can get a trace of the evidence. And natural material that includes all these cloth, carpet, genetic objects includes sorry generic objects that includes door, wardrobe, anything. It could be generic, could be any object. Electronic, yes, nowadays is the cyber crime is increasing day by day. So it says that there was a great scientist called Edmund Lockhart, and it's known as the Lockhart principle. It says that whenever anyone commits crime, he always leave some traces of his personality, his body part at the scene of crime. And wherever he goes, he carries some particles, some traces from the crime scene. So it's called in Edmund Lockhart's exchange principles. So it will never happen that you come into interaction, or you come into contact with anyone. Every point in time, you are carrying something from that contact, and you are leaving some traces of yours to that contact. That's known as the Lockhart principle, and on that basis only the forensic science operates. So likewise in the cyber world also, there would not be any single actions on this cyber world, in the metaverse, wherein you will not leave your digital footprint. You will always, no matter you feel that I have deleted WhatsApp, I've deleted my call records, I've deleted my Instagram account, no matter whatever you do, whatever you write, or what, I mean, in whatever sources, no matter what applications that you are using, everything, every single word, every single image that you are sharing on this metaverse is getting recorded, is getting preserved, and you are always leaving, I mean, we all are always leaving a digital footprint in this thing. It only the matter of time and techniques how to extract this digital footprint, and that becomes the electronic evidence. So as I said, this is the Lockhart principle. So apart from Lockhart principle, we have the principle called is principles of comparison, that only those things which are similar in nature can be compared, and this principle stresses upon the need of proving similar samples and specimen, because no two samples can be similar, no two samples can be compared, because we all are different individuals and we all have different DNA. So, and that's the reason that DNA is being considered as the gold standard. And the other principle is that law of circumstantial facts, because facts do not lie, men do. That we all know. So it's all about our capability to extract the truth from the circumstances. Otherwise, circumstances and the facts which are there cannot lie. The only thing is that we can't extract the truth from the facts. So that is what we need to rely upon different techniques, and we have to rely upon sciences. We have the Swami Sadhanand case. There's a very famous case. You all must be knowing about it. Yeah. And the challenge is that reliability of forensic evidence. As I said, if we are not following SOPs, then there are judgments wherein the court has passed a stricture that you have not collected the sample properly, not preserved the sample properly. So yes, we have the issues with reliability in terms of if the SOPs are not followed. Even today, under forensic evidence is being admitted as under section 45, is being considered as an expert evidence only. So that's probably one of the challenge as of now. And then the other challenge is that all these FSLs and the other allied laboratories are so overburdened. They all have a backlog of cases like what we find in judiciary. These FSLs also so many samples lying in the docket, waiting to be getting examined. And the more they wait, I mean, the more number of years or months they are being there in lying untested, unexamined in the FSLs, they may lose their evidentiary value. That's also biggest challenge that we are all facing. And the other important thing is that holistic training of the entire justice delivery professionals, that includes the judicial officers and the PPs and the defense counsel on these issues of forensic evidence, is also something which we are required to strengthen. So this is just a graph of the role of forensics in conviction. Is all about the collection of the samples, storage, processing the sample. This is what I discussed is the same thing. Yeah, significance of forensic in criminal justice system. Yes, every acquittal should be understood as a failure of the justice delivery system. And in serving the cause of justice, likewise, every acquittal should ordinarily lead to the inference that an innocent person was wrongfully prosecuted. So these are very important facets of this is a jurisprudential issue basically. And how do we resolve this jurisprudential issue with the help of forensic science? That's what we all have to ponder upon. And with this, I end over here. And if you have any questions, I'd be very happy to answer it. Thank you.
Good morning, ma'am.
Morning.
Ma'am, I had a question with regard to this was the procedural part of how the forensic works. But then, what is your opinion with regard to the comprehensiveness of the provisions under the Evidence Act?
What is my opinion on?
How comprehensive are the provisions under the Indian Evidence Act, which can accept these, or should we still go with judicial decisions?
Well, I think, so far we have not been facing any problem under Section 45. Yes, it all depends upon the case to case, but if your forensic evidence which you want to rely upon in the court of law and is being properly it is extracted through the duly observed SOPs, I think there should not be any problem. As of now, we don't have much of the scope of changing and amending the Indian Evidence Act. So I think we have Section 45, and we have many convictions and many judgments wherein Section 45 has played a very vital role. So I don't underestimate Section 45 so far is the forensic evidence is concerned.
And one more question. With regard to the confession which is made to a police or to any other person other than a judicial officer is not valid. So if through any of these procedure or process, if a confession, the statement made by the person has been recorded, how would that statement be valued?
No, it's not any confession made before the police officer is not admissible in the court of law. So we need not to worry about that statement at all.
No, ma'am. I mean, when it is being recorded, when a statement of the accused is being recorded through any of these scientific process.
No, then also, if that recording has some kind of a forensic examination through some, but then that recording having some kind of a I mean, that recording, according to me, cannot be placed before the considered as a forensic evidence, even through the layered voice analysis techniques, because you don't know that how this particular statement was being made. Through what techniques this statement was being made before the police officer. So, I mean, I do not consider it is as a forensic that we can do the forensic examination of this kind of a statement. I'm sorry if I understood your question correctly. I don't know what you wanted to ask and what I have understood.
Madam, I have one question. What is the interface between forensic evidence using an accused DNA or any body fluids and right against self-incrimination? I ask this because though he may have left his DNA, say he has left a hair, but to match that, you have to take a DNA sample from him.
No, not necessarily. Not necessarily. Though, if you we are my body fluid is being taken, or my hair sample is being taken, and it is being found at this crime scene, and then just to match the DNA, if it is being collaborated, I think not necessarily that it falls within the self-incrimination. Now we have CRPI. Most of you may be aware, Criminal Law Identification Act of 2022. The rules are also now into public domain, the SOPs. Now we are going to collect the samples of every accused person. So that has become already the order of the day now. The law is already passed. Unless and until it's getting challenged in any court of law, it is going to be enforced. And you must be knowing that NCRB, National Crime Record Bureau, is a nodal agency appointed under the Act. So now we are going to collect all kind of evidences in abundance. All these accused, any FIR that is being lodged against anyone, it could be you, it could be me, it could be anyone. We are going to have all our measurement, all our, all the 5 things are getting now being recorded, and it's going to be preserved for 75 long years. You must be aware about the CRPI Act of 2022 now.
That's welcome, but then we should see if it would stand the test of self-incrimination.
That's what I added the word. So far, I know it's being challenged, right? I did mention this, yeah.
Thank you, madam.
I believe Mr. Adesh Kumar has raised his hand. If you would like to ask a question, sir.
Okay. Good morning, ma'am. Good morning to all of you. Am I
Yes, yes.
Assistant Professor in Faculty of Law, Banaras Hindu University. And ma'am, I am glad to inform you that the Law School, Banaras Hindu University, is running a PG diploma in Forensic Science and Medical Jurisprudence. So as you told that all the NLU are collaborating with you and your institute regarding the model draft of course curriculum. So definitely I would like to have that model course curriculum, and then I will inform the authorities that it should be implemented in the Law School Banaras Hindu University also. The thing that I want to ask, that we have a lot of biological data of the Indian citizens in the form of Aadhaar card. And India is also one of the foremost countries in the satellite technology. So with the use of satellite technology and the Aadhaar data, can we use the AI tools to detect the criminals and their record for the forensic science? Is it possible in the future or not?
Yes, yes, it is very much possible, and the work is already under progress. It's going on.
Yeah. Okay.
As you rightly mentioned, we are the highest in the world when it comes to the Aadhaar data, the kind of a data base we have. It's enormous. And how do we use the data for the greater good? There's some, I cannot disclose this thing as of now, but yes, there's something that is going on in this regard.
Because ma'am, most of the culprits, they are absconding in the cases of crime. Our administration or police administration is not able to find them properly. Maybe they are overburdened, or the ratio of policeman and the citizen is very large. Or in Uttar Pradesh, there is one constable over 2 lakh Uttar Pradesh citizens. So this is the thing which can be used in the future, I think.
Yes, yes. So there is something going on already. Some studies is already, some project is already underway on these issues.
Okay. Thank you,
ma'am. Hello.
Yeah.
Hello. Please. Yes.
Hello. Good morning. I'm Dr. Sonali Kusum. I'm faculty in Tata Institute of Social Sciences, Mumbai. Very glad to be here, and thank you, ma'am. It was nice listening to you. And I also want to inform that our institute, TISS, School of Law, is also seeking to do an MOU with an FSU, your university. We are also trying to see to it that we can have some collaboration, and we can bring this kind of interesting course in our course outline. Now, ma'am, I have a brief observation and a question. A brief observation is that when we talk about forensics, basically we say it will expedite the matter, but over a period of time, forensics, specifically in POXO cases, we have seen that the POXO cases are kind of delayed by, waiting for the forensic FSL report. So it's also very self-defeating when we say forensics are helping to expedite the matter. So this is my observation, and one question I have, ma'am, probably you could throw some 2022 and the applicability Criminal Identification Act 2022 and the forensics. If we can have just a brief comment from you on that.
Well, coming to the first observation is right observation. POXO is mostly, when it POXO cases is all over the DNA extraction, right? And I would let you know that if you look at the DNA extract technology, the all equipments that we are using is now we are trying to make it in indigenous tools and technology, but it is all mostly the foreign players are all involved. Now the government is now promoting the indigenous technology and make in India products, and there's some progress that is already being there. But the kit, that is being used, one is the whole instrument, and second is a kit for DNA extraction. Now, for both the things, the kit is also now we are trying to get it being make in India kit. So there are multiple factors. One is there may not be a kit in the kit in the FSLs, the kit that we generally used to procure from the other countries. This is the ground level realities. The third is that there are so many samples that the FSL is receiving. There may be only one DNA expert who is dealing with this. And when it comes to these all standardization techniques of these evidences, there's a lot of documentation that you have to do. So that is, so my point is one is the lack of manpower, lack of the technology and the resources, and then the overburden, a huge number of cases. So all these things is putting pressure in the system, and then that's a reason, according to me, is taking a lot of time, and which is very unfortunate. Now, that's the reason that we are preparing the forensic scientists, DNA experts, so that can be, there is a huge amount of employment opportunity that is getting generated at every new places. The different labs, the forensic labs are now getting set up, forensic campuses are getting set up. So it's we are into the expansion mode as of now. So it may take another 3, 4, 5 years to get stabilized and to match with the need of the experts and technology, everything. So yes, we have started, but it may take some time. But yes, you are right. As of now, it is taking more than time than expected. The second, CRPI and forensic. Now, CRPI is all about the that works on the preventive mechanism. I mean, it's all about the prevention and the precaution mechanism in order to ensure the conviction in the later case. Yeah. CRPI and forensic doesn't have any any nexus per se. CRPI is all about the collection of different kind of data from the accused person, so that this data can be further used when the crime is getting committed and can match. So we are creating a database through this, so that this is not new. I mean, US has already had a DNA data bank. We now talk about a lot of privacy issues and the self-incrimination. Yes, we do agree. But when we talk about the United States of America, they are always being considered themselves as the biggest and the idealist democratic world on the. So when in that US democracy, which is considered as a very liberal democracy, which they are claiming, in there also in the when it comes to the DNA data bank, which is already operational, right? So CRPI is basically is on the fundamental principles of preventive mechanism and ensuring the certainty of the conviction at a later course of time.
Thank you, ma'am. Thank you so much.